Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book which has come to us from Wildy, Simmonds and Hill Publishing. It's an important book for practitioners. It's got the title, simple title, Advocacy, a Practical Guide, and it's been written by Peter Lyons, and there's a foreword from Lord Pannick, Queen's Counsel. As I say, it comes to us from Wildy's. They produce some very useful books for us in the practitioner field, both of help to unrepresented parties as well as to professionals at all levels within the legal profession. I've given the title for this book review, which I've written with my partner and wife Elizabeth, A Fundamental Purchase for All Trainee Advocates in the 2020s. That's what you've got. Fortunately today there are quite a lot of books about advocacy which are available on the market, and it makes life a bit easier because it's one of those subject areas which can be quite difficult for many people. Let's look at the book first of all. It's a paperback from Wildy, Simmonds and Hill. There we go. There's the spine. Then there's a little bit of blurb on the back, a little quote from Lord Pannick. The quote is, "I have read no better guide to the practicalities of good advocacy than Peter Lyons' book. It's informed by years of experience and by a wealth of illuminating anecdotes that will instruct and entertain all advocates, from the novice to the QC. It's easy to understand, comprehensive from opening submissions through cross-examination to final speeches, and, as one would expect of a book on advocacy, completely persuasive." Couldn't agree more with that. There's the book. It runs to something like 260 odd pages. At the back there's an index by page numbering. Quite a useful index actually. It gives quite a lot of stuff, so you should be able to find things quite easily. There's a bibliography, practical guide at the back. Some of the rather useful acknowledgements there to tell you where stuff has been taken from. Then a further reading as well. Again, quite useful. All the usual suspects are there, by the way, in terms of advocacy books, many of which you will probably have seen over the many years that you might have been sort of dealing with this subject. The one I will draw your attention to, He Taught Me, is Richard Buchan, and The Art of the Advocate. It's still a very good book even now. The front of the book is there, front page, and there, and there's some blurb on the side. There's a useful foreword, which is well worth reading, by Pannick, and then the contents section. You can see the various contents, talking about starting off with presentational skills. This book is actually relevant to a lot of people in the wider community, in my view, because it's sensible in terms of what it's putting forward in general commentaries. And then you get in total 14 chapters, submissions of law right at the end. That's the detailed stuff. Then there's a case study, which I'll talk about a little later, and further reading. Then you've got details about Peter Lyons, Australian barrister. Then there's an introduction which is worth also reading because there's a lot of detail in it from Peter. And then you start with presentational skills. Right at the back, as I've said, there's a case study which is very similar to the type of practical training exercises I had at the bar. You can see the structure there when I was studying, and you can see all the various documents that are there. Running through the book, you can see how it's structured. Sub-numbered paragraphs and sections within each chapter, and quite short sentences from time to time, as is one's view about advocacy. It depends very much on what you're doing, of course, and what skills you need. But this is what I say, Elizabeth and I having talked about the book. There remains a school of thought which suggests that advocacy is not a subject which can be taught. You either have the ability to be an advocate or you don't. Some go further and think that an advocate is merely a quick-witted actor able to lie effectively for the client. Now, there are lots of people with different views, but advocacy is a particular art. I think some people are born with certain skills and some people have to nurture them, bring them out, draw them out a bit. And this book is actually, I think, here to help people who might have a slight difficulty when it comes to the presentation of particular points, submissions, speeches and so forth in court and sometimes in the wider arena. Obviously television today is a slightly important area which hitherto wasn't as significant, but it does in fact require certain advocacy skills there as well. And of course our view about my original school of thought that it's something you actually have or you don't have is actually what we say wrong again, because what Peter Lyons does with this book is he admirably demonstrates in the new work entitled Advocacy, with the subtitle A Practical Guide, coming to us from Wilder's, exactly what you need to do in the modern era. And his view is clear that, quote, advocacy is a skill, and mastering a skill means acquiring a technique. Exactly so. You need, as a potential advocate, what he goes on to describe as hard work, experience, and a dash of talent. And I think he's right about that, because you do need to have that extra something to stand out in the crowd. It doesn't matter where you are. It's just one of those things that you do have to have. And there are I've met a large number of very good advocates. I met some ones that are not quite so good. But the ones that are very good do stand out in the crowd. They are, to some people, attention seekers. They're not quiet persons. They're all sorts of different people. But it depends on exactly what sort of skill you need in what sort of forum, whether it be a courtroom, the House of Commons, or a television studio. And we think, of course, that this book is also highly relevant, as I say, to non-lawyers and unrepresented parties in court proceedings, because quite often they won't know much about what to do. And I think this would be a good guide and friend to them in the courtroom. Now, the author's mission is to help all those people who wish to learn essential advocacy skills, as well as those who are seeking to make their advocacy more effective. In other words, the beginner and the more experienced. And Lyons shows how to overcome nerves, how to present clearly and ethically, and how to undertake case analysis. That last part, I think, is absolutely fundamental, because we call it case management, if you like. It's the management, the fact management of what you've got, so that you are absolutely on top of your brief when it comes to the presentation in court. It's a formidable task, of course, and I think Lyons succeeds brilliantly in making this book readable for potential 21st century advocates, because frankly the styles have changed over the years, and I'm a man very much perhaps wedded to the 80s, I suppose, 90s, 70s, in a different era to a certain extent, prior to the civil procedurals, prior to some of the things we have, which have actually restricted quite a lot of our advocacy skills in one direction, but increased them in another, just in case the people doing the bar course are worried about what I'm saying there. But you will see what I mean when you read the book. And of course, from the vantage point of legal practice, this small paperback must be read, in my view, by all aspiring barristers and solicitors who are intent on courtroom work, because the judiciary continues to criticise some of the standards of advocacy skills that are currently displayed before them in proceedings. They've been moaning about this for some time. Now, it's understandable. I'll give you the tip. If you're doing any form of training, you go and sit with a judge for a day in court, and you actually go in with the judge and sit on the bench with him, and you see what's before you, you'll pick up what I'm saying quite quickly, because there are occasions where the advocate doesn't seem to quite have a grasp of what he's talking or she's talking about. It doesn't happen very often, because I think the bar in particular is an extremely highly professional body, and the quantity of the advocacy today is absolutely top rate. And that's, of course, my biased opinion, but what would you expect? Obviously, advocacy, then, this book, I think, redresses the balance for the modern courtroom era. And of course, Lyons also offers the legal profession at all levels excellent advice on how to succeed in the fundamental areas, which are referred to, of course, by Pannick in his little quote at the back. But that covers this list, if you like, of what you'd be expected to know a lot about. It's part of your training when you're actually doing the bar exams and the vocational stuff. Then it becomes part of your training within pupillage. But you do need to know how to do the following. That is interim applications or motions, handling witnesses in examination in chief, that's direct examination. Obviously that's more relevant now to criminal proceedings than civil. And of course in cross-examination, which is the key. You've also got re-examination, and always remember not to re-examine if you don't need to. Like I did the other day, I decided there was no re-examination because there were one or two minor points which the judge might have asked about, but I didn't need to do the re-examination. There wasn't any need for it at all in this particular trial because we'd adduced everything we needed. The only person then that needed to, because it was civil, needed to have some reassurance was the judge because he's making the final decision. Of course, in addition to that, you've got things also making speeches of law to a court or a panel, and of course what we call trial speeches, which are named just a few of the areas. Trial speeches are important because, again, the summing up can be quite important because there's no point in saying things and overemphasizing certain things when in fact you've already made the sale, if I can put it that way. You do need to crystallize very carefully what you actually need to say so that you're always relevant throughout. Of course, what the author has done with this book is he's intentionally included a section on written advocacy, which is always, I think, heavily underrated today by the qualifying training courses, because I know things have changed, but today the emphasis on the written word, and it's something that clients quite often don't understand at all. You've got to actually be very clear about the quality of what you're producing. That's the pleadings, the witness statement, and so on, because they've got to balance and they've got to be the same type of document. They've got to have the same story, because otherwise that is where you've got your real defence problem immediately, because the defence can see if, for instance, the pleadings, that's the claim, and the witness statement have inconsistencies. It's the same in any jurisdiction. The inconsistencies can destroy the case. So what you get from the book is superb advice on how to write persuasively and how to draft submissions and effective skeleton arguments. Again, I think that's very valuable in today's modern court arena. Now, finally, let me just say this book is primarily aimed at barristers, solicitors, arbitration lawyers, patent attorneys and students. So do read his introduction very carefully before you go through the 200 odd pages. The appendix at the back I thought were particularly helpful. So do try out the case study at the back, because it is basically a practical training exercise once you've read the main text. It will probably fill in a few gaps for those who probably are not quite as knowledgeable as others, and it's not a criticism or anything, it's just that some people have more knowledge and expertise than others. And we feel, of course, also that international lawyers will find this book very helpful as well, providing as it does a better understanding of common law practice here, with basically the emphasis on the type of cross-examination you have in the England and Wales jurisdiction. And I'm not commenting about America or anywhere else and all the stuff on the television, most of which is garbage, frankly, because they don't understand what we really do. They're putting into a few seconds what we take to do in quite a few hours sometimes. So it's a different approach, but you've got, for advocacy purposes, follow the book and you should have no difficulties whatsoever. Well, you'll have a few, but this will help iron out some of them. The paperback edition of the book was published on the 28th of February 2019. Let me just open it and show you it again. There's the front, spine, and then the back. And then if we open it in the middle, interim applications, motions. This is in the interlocutory process, the structure of your submission, making the judge's job easier. I think that's a wonderful expression because that's actually what you're there for. You can see that the print is quite small. Cross-examination, again, there are lots of books on cross-examination, and I do think it's always useful to read them because one question here, is the cross-examination necessary? Do think about that. Putting your case, do think about that. And of course, the key is always preparation. Final word, thank you very much to Peter and to Wildy and to the commissioning editors and everybody involved in this book. You make our lives easier by producing these works, and a very big thank you goes to all of you. Thank you very much. Bye-bye.